presentation on victim advocacy and victims' rights with our partners from the Contra Costa District Attorney's Office. I think you're going to learn a lot, and I think you're going to be inspired, really. Before we start with our presentation, I want to remind you that we have a lot of people here today, so please keep yourself muted so that we could all really pay attention to the presentation. The slides that will be shared will be available and will be emailed to you. So you don't have to worry about like, oh, I missed that slide. You will all get the full deck today after the workshop. Also, I want to remind you that we are going to send you an evaluation form. We'll be asking you to fill it out so we could continue to improve the content of our Family Justice Institute workshop. I think I might have mentioned this is our last workshop of 2023. We've had really great workshops this year again. We started this program, Family Justice Institute, I think 2015 or 2016, and we have created this wonderful, beautiful learning community together, so thank you. And in 2024, we are gonna bring probably another 20 to 25 workshops, so please stay tuned, send the link to your colleagues so that we could have more people learning together. And also, if you are interested in learning about any particular topic, please feel free to email us at cocofamilyjustice.org so that we could look into the topic and look for presenters and create workshops together. Really, our goal is to co-create the curriculum and agenda together with you. So that's enough for me to say. And now I'm going to hand it over to Alana Matthews from Contra Costa District Attorney's Office. Alana.
Thank you, Susan. Hello, everyone. Thank you for coming and joining us today. We hope this presentation will be helpful, just as helpful for you as a community member or in your role in whatever it is as your job. So I know that Susan had everyone put down what their agency is, and some of you have included your role, but not everyone. So we want to know first who all is in the room. Like, what role do you have? Are you an advocate? Are you a nurse? Are you just a community member who wants to help us? Because we want to make sure the information we're providing is relevant to you. So if you can put down what your specific role is, if you are an advocate, if you are a probation officer, if you could go ahead and do that for us, we would appreciate it. So let's just take 30 seconds and everyone can put it out. Thank you, Jasmine. Thank you, Leslie. I see we have a therapist in here. We have client advocates. Thank you, everyone, transitional housing advocates. And then also, this is important to know because we may want to get a copy of our chat as well. And that way we get to see who the resources are in the community. So not just the agency, but the role that you have. And that can be more meaningful as well. All right, so we're going to get started. First, I just like to say that this is dealing with Marsy's Law and victims' rights. So some of this may be heavy, and I'm probably preaching to the choir, but there might be some triggering information. So take time to take care of yourself. If you need to get up and walk away, if you need to turn your screen off, we certainly want you to be able to do that. And just acknowledge that some of the content may be triggering. It may reveal some trauma. So we want to just make sure everyone is aware of that. The second thing is for this presentation, we have certain segments, but if you have questions, go ahead and put your questions in the chat. I will be monitoring the chat and we will pause and ask questions, but we'll also be scanning because there might be 2 or 3 questions along the same line. So you can use the chat for that. You can also use the chat for gratitude, and you can use the chat for comments or information. Since we see that we have so many individuals throughout the community who are providing various services, then we want to make sure if you have something that you can share and add, that you are able to do that and you can use the chat. All right, thank you all for that. Just so that you can make sure you're in the right place, this is the Marsy's Law and Victims' Rights presentation. That's what we are here today. And we have 3 goals that we hope to achieve today. And the first one is we want you to understand Marcy's Law. There's 17 enumerated rights given to victims in our California Constitution. So we want to make sure you walk away with a good understanding. Also, a lot of times in our spaces, we talk about victims and survivors, and they have different connotations. We will use the term victim a lot, and it is not to have any other indication but the significance that the California Constitution places. So it gives rights to victims. So we don't mean to minimize or keep people, stuck in a place of, a horrible incident. We understand there are survivors and the significance of that terminology, but we are specifically using the term victim because of the special connotation it has within the California Constitution. And then the third objective for today's course is to identify ways in which you can help and support victims. So whether you're here as a community member or you're here in your professional capacity, or maybe you're a volunteer, we want to be able to equip and have you leave. So we're going to work through some exercises to help you kind of flush out what are some ways that you can be more supportive. So with that, I will do a quick presentation overview. I'll start with giving you some background information of Marcy's Law, because we've already done, as you see, or you can go to the agenda. Next slide. All right, so we've already handled our introduction and our housekeeping. Our presentation overview is pretty simple. It's right here. We're going to do a little background of Marcy's Law. Then we're going to jump right into those 17 enumerated rights. And then we'll have a breakout session, and then we'll have a report out and open it up for any additional questions that anyone may have. When we open it up for questions at the end, you will not have to use the chat. You can simply raise your hand. But I would be remiss before we actually start it without acknowledging my team. I am Alana Matthews. I am an assistant district attorney here in the Contra Costa County, and I am joined today by three wonderful colleagues. One is Kristen Busby. Kristen, maybe if you could just wave your hand, you'll see her later on. She is one of our deputy district attorneys here in this office. And also she is joined with Shannon Mahoney, who is the program director of our Victim Witness Services program. They will actually do the second part of the presentation dealing with the enumerated rights. And we also have DeWanda Joseph. If you can wave your hand, she is going to be assisting with our breakout sessions, and she is one of the victim advocates in our office. So with that, we'll start with the background. Next slide. So I want to tell you the story of Marcy Ann Nichols. She's affectionately known as Marcy, and that's where we get the title of Marcy's Law. She was born on March 6, 1962 in Cincinnati, Ohio, to Marcella and Henry Nichols. And a few years after she was born, they decided to move to California. She was described as having a heart of gold. She loved working with animals. She graduated from high school and wanted to focus on becoming a special education teacher. Prior to her college graduation on November 30th, 1983, Marcy was stalked and murdered by her ex-boyfriend. She was only 21 years old. Her boyfriend of 5 years was just a carpenter who lived in makeshift quarters, and he invited her to come to his house after she had broke up with him. And when she arrived, that's unfortunately when she was murdered. 1 week after her murder, her parents did the very hard and difficult job of burying their only daughter. When they left the funeral, they decided to go by the grocery store, stop and get some bread. And when they went to pick up that loaf of bread, while in the checkout line, Marcy's mother was confronted by her daughter's murderer. That's right. Within 1 week, he had been released. And more devastating than that, the family received no notification. They had no idea that he had been released on bail just days after her murder. Well, The defendant was ultimately convicted and received a life sentence with the possibility of parole. So every 2 or 3 years, the Nichols parents had to drive down for the parole hearing and make their case to the parole board. But they decided to make their case actually to the entire policymakers and legislative leaders in California, that the stress and trauma remained, and it was tough for them, and it was additional trauma to have been confronted without any notification. So it took from the 1980s until 2008, when Proposition 9 was finally passed by the California legislature and created the California's Victim Rights Act of 2008. So that's the background, and that's the story of why we're here today. Next slide. So in the Constitution, victim is defined as a person who suffers direct or threatened physical, psychological, or financial harm as a result of the commission or attempted commission of a crime. And who is a victim? If you can enter, so we can have the next part. That would include spouse, parents, children, siblings. It could be a guardian or lawful representative of a crime victim if that crime victim is deceased, if they are minor, or if they are incapacitated. So now that we have a little background on who Marcy Nichols actually was and who this law is named after, and we have an understanding of who is considered a victim and entitled to all these rights, I'm going to now turn it over to Kristen and Shannon to talk about those rights. Next slide.
Good morning, everyone. My name is Kristen Busby. As Alana said, I'm a deputy DA here in Contra Costa County, and I am joined by my friend and colleague.
My name is Shannon Mahoney. Good morning, everyone. I am the Victim Witness Program Manager here at the District Attorney's Office. So we're very happy to be with you this morning, and thank you, everyone, for joining us.
We are going to talk about the rights that are enumerated in Marcy's law, but we're also going to try to make it a little bit interactive. So Nick, if you could hit the next slide. So we don't have the digital poll for this one, but what we're going to ask you to do is to enter into the chat what you believe the answer is to this question. Who you think determines if charges from a criminal incident are filed. Is it the police? Is it the crime victim? Is it the district attorney? Or is it some other person or entity? And while we let some people enter in their chats, maybe we'll just say a couple things. You know, victims' rights it's a huge part of our job here at the DA's office. It's an important part of our job. In some way or another, most crimes, well, for our most serious crimes, they pretty much all have a victim, right? And we have an enormous caseload, which you probably could guess. So we do spend a lot of time trying to communicate with victims, et cetera. And at the DA's office, we are fortunate enough to have an entire crew of people who work in the Victim Witness Program who make a lot of those contacts and keep up with a lot of our crime victims. And we're fortunate to be able to provide that service to the community. All right, so looking through here, let's see. It's like, it reminds me of Who Wants to Be a Millionaire polling the audience here. And I will say that if you were all in the audience of Who Wants to Be a Millionaire, that contestant would be very lucky because it looks like pretty much every single person got the answer right, which is that yes, the district attorney's office determines whether charges are filed. Nick, could you hit the slide? Okay, so talking briefly about the path of a criminal case. You know, criminal incident occurs, then the case is packaged up by the police department. They bring it over to the DA's office, and we can do one of two things. We can refuse to file charges for any number of different reasons. For the most part, it's an insufficiency of evidence. We don't believe that we can prove the case beyond a reasonable doubt, which is our legal obligation and an ethical obligation that we have. Or we can file the charges. When we do that, we create the packet, we send it over to the court, it gets scheduled for an arraignment. That is the first time our criminal defendant comes into court. They're represented by an attorney. The judge asks them how they plead, and at that point, they're all pleading not guilty, and that's the start of the criminal process, really. At any point after that, plea negotiations could take place, and the next evidentiary hearing, and we're going to be primarily talking about felony cases here because we're talking about sort of the more serious crimes in our community today. A preliminary hearing is the first evidentiary hearing that happens. There's no jury. The DA goes to court, the defense attorney and the defendant go to court, and the DA presents police officers or other witnesses to show to the court, basically, in simple terms, probably this crime happened and probably this is the person that committed the crime. The court sort of stamps it, says you're good to keep going forward with the process. And the next evidentiary hearing that could happen is a trial. And again, at any point during that process, after they're arraigned and they plead not guilty, we could negotiate the case for a plea or resolution. And whether a plea is reached or whether a trial occurs, assuming there's some sort of a conviction, the next thing that happens is sentencing. Go ahead, Nick. Okay, so I believe we actually have the interactive poll for this one. So the question is, can a case get filed without the consent of our victim? Okay, looks like our voting is just about stopped, close to being stopped. And again, if we were polling the audience, the contestant would be lucky, as the vast majority of you are correct. Cases absolutely can and do get filed without the victim's consent. From the outside, that may seem sort of like an odd proposition, but you know, in criminal cases, the criminal case is not Jane Doe versus John Doe. In a criminal case, the title of the case is always the people of the state of California versus Shannon Mahoney, for instance, right? So the plaintiff in the case is not an individual. The plaintiff is the state, because what we do is enforce the laws of the state of California. And the state of California and the people of California have an interest in prosecuting those laws, even if the victim does not want us to prosecute. Really common examples of when we see this, most common really is the domestic violence context. I suspect that from reading sort of people's bios here, most of you have some context of that, the cycle of violence, and how that works. Sometimes we have domestic violence victims that are gung-ho. They've sort of reached the end of their rope, or stalking victims, for instance, tend to have already sort of cut off that contact, and so they're going to be on board. But in the majority of cases, we have domestic violence victims who do not want charges to be filed. Sometimes they're sad about it. Sometimes they're very angry about it. And that's really the first point of conflict that comes up in the criminal justice system when we're talking about Marcy's Law rights and then what the criminal justice system is going to do. And it's really difficult to reconcile those sometimes in cases like this, but it's a call that we have to make every day here. And in the end, victim safety and public safety sort of prevails for our office. But then it becomes our job to have these tough conversations with crime victims. And our victim witness advocates are very talented when it comes to that. And so for the most part, even when people are upset, they come to understand the process. Go ahead, Nick. All right, turning it over to Shannon.
Okay, so just to give a little bit more background about how our office works in these cases, and just for the purposes of today, we're really talking about interpersonal violence on a felony level, because that's what a lot of us here today work on. And so one of the things to just know about how the district attorney's office works is that most of our interpersonal violence crimes are assigned to vertical prosecution units. And that means that if it's a domestic violence case, a sexual assault case, elder abuse, human trafficking, child abuse, a prosecutor is going to be assigned to handle that case from beginning to end. And as part of that team, we also are going to have a victim advocate assigned and usually an investigator assigned. And that prosecution team is going to work together. And part of the way that we do that work is through Marcy's Law. Marcy's Law is a belief system that all of our worlds kind of spin around. It is a piece of every conversation, every court date that we're thinking about is keeping in mind these 17 different rights under Marcy's Law. And so we want to talk some about what that looks like. So one of the things first to remember, number one is really important. These cases come in and they are police reports and evidence, and attorneys are pouring through the information and getting ready to go to court. And what we all keep at the front of our minds is every one of these cases is attached to a life, and a life that has been severely impacted by whatever crime the person has been through. And so always keeping front and center with our victim advocates, our prosecutors, that we want to connect as quickly as possible with the victim of the crime and their family members, right? Because Marcy's Law also includes the family members of the person that was harmed. And to ensure that we are talking to them about how they feel about the case, explaining what it looks like, understanding what their needs and concerns are so that we can start to address it, and ensuring that the victims of crime are as involved in the criminal process as they want to be. So these rights are out there for every victim of crime. Victims and survivors often choose how much or how little they want to be involved, and we want to hear and respect that. So there are families at some points that want to be very involved. They are here at every court date. They want to talk about every court date. And there are some that we want to respect and let them try to heal and give them the space that we're going to give them the information as they want it and involve them as they want. There are some points where people do have to come through into the courtroom at times. On some cases, it varies depending on how it moves forward. But we work really hard as a team to ensure that we know what each person and each family are kind of looking for. And that's part of this, treating people with fairness and respect. The other piece of that is making sure that we are asking to look at what the person's situation is, because we're here talking about court and what that criminal case is going to look like. But the person is still out there living their life and going through the impacts of whatever the crime was. And so we want to make sure that we are, especially the interpersonal crimes, working on getting a criminal protective order in place, looking at what needs to happen in terms of, does the person need to relocate? Do they need home security upgrades? What resources that can we connect them with? And sometimes victims want to come into the court and address the court with regard to bail and release conditions. And that all can happen very quickly as we get going into a case. So those are all things that we're talking about as a criminal case begins here. The other part is really trying to make sure that we are protecting the victim in terms of their confidential information. So there are times, especially in interpersonal cases, where a defense may be looking for counseling information or school records or things like that. And so we work with our families up front to try to know how people feel about those things so that our attorneys can go into court and object on the victim's behalf to help protect all of a victim's rights under Marcy's Law. So those are all pieces that we're talking about kind of early on in the case. My next slide.
And sort of going back to what we were talking about before, being able to refuse an interview and not being in a position where you are forced to speak about the incident or the crime, that's part of sort of being treated with dignity and respect. With that said, right, a person does always have to participate once they are under subpoena and they're in a court of law. But other than that, they're allowed to have as much space as they want. And at our office, we do let them know that. Because sometimes, you know, when you're approached by a defense investigator or who knows what, people don't really realize that they don't have to engage, but they absolutely do not. And the next two are really about notice, notice, notice. And just like in the example of what actually happened to Marcy's parents, it is really important that people be told, okay, you know, the case is next on for a setting, or the case is next on for an evidentiary hearing. What does that mean? When is it happening? Because it doesn't feel good. I sometimes think of it as, you know, treating these victims the way that we would want to be treated, right? We don't want to be surprised by things. And so we have to make sure that we're taking the affirmative steps of letting them know, you know, at every stage that the case is in and as it progresses, and letting people know that they are absolutely allowed, and we welcome them into the courtroom and into the process to understand it better. Go ahead, Nick. Here we are with another one of our polls. So, true or false, a victim can only address the court when they are called as a witness. All right. Looks like our voting is slowing down. Once again,
We still have about 35 seconds. The poll's still open.
oh, I'm sorry.
That's okay. Yeah, we have 86 participants and look like we have about 60 so far. So we're still waiting on a couple of more. We'll give it 5 more seconds and then we'll end the poll.
And don't be shy. I can't tell who's voting which direction. Oh, all right. Oh, do you guys share the results? Is that how that works? Anyway, so once again, a vast majority, absolutely correct. While what I said earlier is true, that the only time a victim can be sort of forced to speak is when a person is called as a witness and they are sworn under oath and the judge quite literally orders them to answer questions. They have the right to be heard. I mean, pretty much at every single proceeding that happens on a case. And I know when I was explaining the sort of the progress of a case, it looked like there were only a few different portions. Those are the key portions. Those are the ones that are like absolutely required by law. With that said, and I think most folks have enough sort of general and common experience to know that court cases tend to drag on and on. And in doing so, they're on in courtrooms so frequently, sometimes just to set new dates. At any of those events, you know, the victims are welcome to come to court. They are welcome to speak. Shannon and I were talking about this a little bit yesterday. And again, returning to the domestic violence context, you know, a lot of the time, well, let me say this first, something I'd left out. When a person is arraigned on the charges, that's the first opportunity we have to get a criminal protective order issued. In our interpersonal violence crimes, we do that as a matter of course in every single case right off the bat. A lot of times, and you may not be surprised to hear this, our domestic violence victims don't want a criminal protective order. And sometimes they will come to court, you know, again and again, to make that request to the judge that it either, you know, be eliminated or that it be changed to what we would call a peaceful contact order. You know, it's a funny thing because as DAs and as advocates to our victims, we will sometimes do two things that seem to be in conflict, right? And I've done this before, where I have a victim and I bring her into the courtroom and I say, you know, Your Honor, she'd like to address the court regarding the criminal protective order. And she says, you know, I want the order to be gone. I'd like peaceful contact order. I'd like to talk to him. He's, you know, a co-parent, et cetera, et cetera. And we give them that forum, you know, and then the judge says, okay, what's the people's position? And then we say, nope, it still needs to be in place. It's a safety issue, et cetera, et cetera. But we are sort of simultaneously the person that has told her that she has the ability to do this. And we also encourage her because it's important that she be able to be a part of the process. And then there we are again, sort of this strange point of conflict where we're saying, ta-da, please say what, you know, is sort of important to you to say. And now here we are, and we're going to argue the exact opposite to the court. So it might seem sort of strange, but the truth is these are rights people have. It is important. And sometimes they do sort of come into conflict with what our position is, but it absolutely doesn't stop us from taking those steps. Go ahead, Nick.
Okay, so Marcy's Law plays a huge role in our criminal justice system, especially when it comes to victims of crime being heard. Just kind of expanding on what Kristen was talking about, they can be heard upon request at any proceeding. It could be a bail motion, it could be something on for preliminary hearing, it could be on for a continuance. Certainly at sentencing hearing, victims have a right to be heard. But if any one of Marcy's Law rights are at issue when we come to court, the victims of crime have a right to be able to address the court and share what their thoughts are. And we work with families on that. And again, going back to what Kristen said about these points of conflict, the district attorney's office and our prosecutors have a legal standard about how they're going to prosecute a case and what an outcome might look like for that. And our victims of crime and families may be in agreement with that and may feel very comfortable with what an outcome of a case might look like. And sometimes it's the opposite. And it is a point of conflict where a victim of crime is not comfortable with what an outcome might look like, about maybe a person being out of custody, about safety issues that are coming up, about accountability. And those are all things that we, as a prosecution team, want to spend time talking to our victims about, and having the victim be able to come in and not just share with us, but to share with the court about what any concerns are or the impact on their lives with basically the way the criminal case is proceeding, or maybe about what an outcome might be. And the other place that we see this as coming up a lot, there's been a lot of legislation in the last few years regarding post-conviction issues. So a lot of laws have changed, making many of our cases come back. Some of those are interpersonal violence cases that are coming back maybe for resentencing issues. It could be something that's on for parole hearing, or some other sort of hearing that comes up where our family thought that maybe the case was done, but here we are, we're back in court again. And so we again are following up with victims of crimes and families and making them aware of all of those proceedings, but also inviting them to participate in the hearing by addressing the court. And sometimes people think, well, you know, this person is not in agreement with what the prosecutor on the case needs to do and what the outcome might look like. We absolutely invite victims of crime to come in and address the court to say whatever it is that they want to say. And even if they're in disagreement with the way that the case, the outcome of the case is going to be, we'll stand right next to them and let them share their thoughts with the court. And sometimes the court can take action on that, and sometimes they can't. But it's really, really important for us in this office to ensure that victims' voices are heard and that they have the opportunity to share that impact. And that is a very, very big part of Marcy's Law all the way through. And a lot of times having a victim come and share their thoughts and the impact on their family and what they're looking for can be just as powerful as what a prosecutor can say in a courtroom. And so we really, really emphasize that. And then in terms of Marcy's Law and victims having a right to a speedy trial and a prompt and final conclusion to the case, that is something that we would like to have for people. The reality is the criminal justice system is a very slow process, especially when we're talking about violent crime and cases where the outcome is going to have an impact both on the person charged with the crime and on the victim. And so we do have a lot of continuances, as Kristen was alluding to. We get these set dates or preliminary hearings and they get continued multiple times. So we absolutely invite victims to come in and address the court and to share how those continuances are impacting their lives. Because the reality is we here are getting ready for court every day, but when we have somebody who's preparing to come in and testify on a case or preparing for a sentencing hearing, we're going to impact their life that day. They're not going to sleep the night before. Nobody's going to eat breakfast the morning they're coming into court. They have to miss work. They have to figure out childcare. And so when you do all of those things and we come into court and there's a continuance, it's really, really hard on families. And so we absolutely try to support victims and families and ask them to come in and communicate as much as possible in advance when we know something like that is going to come up, so that we can try to help enforce their right to make sure that that case is going to keep proceeding forward. You hit there you go, thank you. So this might be something that a lot of people don't know, but we actually work very closely with our probation department. And probation, when we're doing these felony level cases, often does a pre-sentencing report, and they are doing an investigation. So they're talking about all the facts of the case and what an outcome might look like. And they also take into account of what a victim might want to see in terms of sentencing recommendation. And so we are working with probation to ensure that victims have the ability to talk to the probation officer that is working on that investigation, so that they and not just the family, but oftentimes friends and community members are writing letters and things that they will attach to that probation report. And when it goes to the court, both the district attorneys, our deputy district attorneys and the defense attorney have access to that, as well as the judge. So it's another space where our victims can make sure that they are involved and invested in what is going to be presented to the court, so that the judge can take that into consideration with regard to what a sentence might look like. And then if they want to receive a copy of that, they can as well. And so that pre-sentencing report kind of comes in when we get to the sentencing phase. And so one of the places where we really want to ensure that victims know their rights and can help enforce those rights is when we get to that sentencing hearing. That is really a time where the court and our deputy DAs and our victim advocates are going to help support our victims and survivors in preparing victim impact statements. That is a day that's meant for them. We have kind of this whole criminal justice process and all of these court hearings where they have a right to address the court, but there's a process in place that we're following, and maybe that day is not specifically about how the victim feels and what it is that they would like to see. The sentencing day is 100% about the victim's experience and making sure that they have that opportunity to say whatever it is that they would like to say. And so often on that day, we have families coming in that are going to read letters or statements. Sometimes they bring pictures. Sometimes people have videos that they want to share. And we really will do anything we can to accommodate any requests that a victim has. And our judges as well are very supportive in making sure that time is set aside for them to say all the things that they would like to say. So that is one of the days that we all work in advance as well to try to help victims feel that they have the space to do that. Sometimes it's an overwhelming thing. And so our prosecutors and our victim advocates are helping maybe read letters for people or read victim impact statements or share thoughts that maybe the victim's not comfortable sharing themselves. So that is something that we'll do as well. So any accommodation that we can come up with to try to help support ensuring that their voice is heard when we get to that sentencing date is something we put a lot of work into.
And just one thing to sort of piggyback on what Shannon was saying there, when it comes to the rights to sort of a speedy trial under Marcy's law, that's another sort of point of conflict that we have with Marcy's law and sort of the procedures of the criminal justice systems, right? Marcy's law is designed to support and help victims, but the criminal justice system is designed to, safeguard defendants' rights. And I know that can be frustrating for victims, but I will say this, as an attorney and a criminal attorney, in the United States, we are so fortunate to have a very strong, very robust criminal justice system. And part of that is because we have so many safeguards and checks and balances that what it means is that our convictions are safe. It takes a lot of time to get there, but there is sort of a cost benefit. And in the end, we are fortunate to have the kind of criminal justice system we have, but there is no question that it can be very, very, very slow. Go ahead, Nick.
Well, actually, we have two questions in the chat. I just want to make sure you were able to see them. The first was from Susan, who says, do they usually request a pre-sentence report?
Shannon, I'm gonna defer to you.
They do request a pre-sentencing report if we go to trial and somebody is convicted at trial. Oftentimes the other way is we go back to our path of how the criminal justice process works. If at some point there's a negotiated disposition, then at that point, there usually is not a pre-sentencing report, but just about every felony level case that goes to a trial where there is a conviction by a jury, there is a pre-sentencing report that gets done and that victims and families can choose to participate in if they would like to.
And the second part of that question, that question is, do you tell them about the availability of the pre-sentence report? Isn't that right?
Yes, we absolutely do. Our probation department usually reaches out to our victim witness team, whichever advocate is assigned, or we reach out to them and find out who's doing this pre-sentencing report. And then we communicate and make sure that that victim knows that this process is going to take place. And we have a timeline because at some point we're going to have a sentencing date. So we have a timeline in which probation is going to write that and submit it. And so we're working with victims in advance to make sure that they have that contact information, and that our probation officer as well as the victim have shared information to connect and have those conversations. And the other thing I know Kristen is going to talk about that goes into that pre-sentencing report is restitution information. So that's another piece that they're going to talk to victims about and include in that report.
And before we go on to restitution, Leslie also had a question about what does confidential by law mean, especially if the victim should know all information.
Yeah, and that's one that I think is like a little bit fluid, right? For the most part, the pre-sentencing reports aren't going to have anything that is too protected. I mean, these are documents that become part of the court file. If there's anything that's really supposed to be protected that's part of the court file, it gets placed under seal, which means no one has access to it without a court order. But with that said, certain things that people shouldn't have, you shouldn't really ever have access to someone's like personal identifying information. So if for some reason it included like defendants' phone numbers or social security numbers, something like that. Those are things that you can't disseminate to people, but it wouldn't be information like about the crime. With that said, you know, juvenile law is very, very different. In juvenile, confidentiality is key. When we're talking about juvenile, almost everything is confidential. Victims are allowed to come to court. Your average person can't come to court in a juvenile context. Whereas in the adult context, all of our courtrooms are public. That is important. That's actually in the federal constitution. But when it comes to juveniles, things are really protected. So in juvenile, we actually wouldn't really be giving out these dispositional reports that we get from probation. And in juvenile, probation is even more sort of hands-on, and the youth's history and sort of family information and everything else, it's really robust. I mean, these juvenile probation reports can be 2, 3, 5 times as thick as the ones that you see for adult criminal defendants. Juvenile files are completely confidential, so effectively, in some ways, right, they're basically all under seal by the courts. Even for us, we have to frequently go through this complicated process to try to get there. So juvenile's a little bit different, but we try to assign people who are more expert in juvenile law when we have victim-heavy cases. In juvenile, Shannon and I have navigated some of those together. They definitely present different challenges, and, you know, juvenile crimes are, I mean, just as serious as adult crimes, especially now. And we've changed sort of the juvenile criminal justice system a lot in the state of California, and our office and most other offices, you know, we're not really charging kids for petty crimes. It's not like that. The crimes that we focus on in juvenile law are the serious ones. I mean, murders for sure. There are plenty of sexual assaults, unfortunately, in juvenile. Carjacks, robberies, firearm offenses, all of those things. And so we actually do have a lot of victim-heavy crimes in there. And that navigation and that dance is trickier and more difficult. Okay, moving on to my slide. Again, this is transparency, information, notice. This is one of the most important parts, right? To talk with the victims of the crime about how this case is going to close, what that sentencing is going to look like, and what it means. And transparency is really huge here, because criminal adult sentencing in the state of California has changed so much, even in like the 11 years that I've been here in this office. They get lots of credit that they didn't used to get sort of before. Now some sentences are served in our local jail. Some sentences are served in state prison. It depends on the crime. The credits you get in local jail are different from the credits you get in state prison. We actually can do a better job sort of calculating anticipated release dates from our local jail than we can when someone goes to state prison, because at this point, we really don't know what the Department of Corrections is doing with credits, who they're giving extra credits to, how much extra credit they're getting. And so that can be very frustrating to try to explain that to victims, where you say like, okay, probably he'll be serving 50% of his sentence. Whereas if we send someone to state prison, we previously used to be able to say in our serious sort of violent cases, he'll be serving 85% of his sentence. Now, for a lot of these cases, they're serving like 66%. But again, we don't know 100%. So what we do for the state prison ones is we're honest about it. We sort of apologize that we can't tell them the absolute dates, but we help them get signed up for something called VineLink, which is a notification system. You can, you know, even right now, if you happen to know Scott Peterson, for example, right, you could type him into VineLink and it
was on CDCR website, not VineLink.
Oh, yeah.
Yeah, so with regard to online registration, when we have somebody that's here in local custody, victims and survivors can sign up online at VineLink, and they can be notified of a person's potential release date. We have one process for that. And then when we get to state prison, now VineLink used to help with that, but now the Department of Corrections Victim Services Unit actually works to get victims signed up in their own system. So everybody that's in state prison in the state of California, you can go, anybody can go onto their inmate lookup system on the Department of Corrections website, and you can look up and see where a person is located, which prison they're located. And victims of crime can register to be notified of release, ask for no contact orders, ask for somebody to be potentially paroled somewhere else. So that's a really important part that our advocates are working with victims on that.
And thank goodness for the advocates, because if we were relying on the attorneys to know all of this stuff, obviously they would be wrong, as I just was. Nick, go ahead. So restitution is big. It's sort of self-explanatory, right? When you are victimized, sometimes there are costs, sometimes there are physical damages, property damages, and there can be costs related to the offense, funeral costs, all sorts of that kind of thing. We do our research, we talk to the families, we have experts here to do it, and we make those claims in court. We got a poll here. Nick. Okay, so let's try to make this one quick. I might stop it before we're all the way done, but the court ensures that restitution is paid, true or false?
We'll give the poll about 5 more seconds. It's pretty close this time.
Yeah.
Okay, much closer this time, but majority is still correct. And this is a weird idea and it's a complicated thing, right? But it basically comes down to the fact that in the United States, we don't have debtors' prison. They actually used to do that in England. And then when we became our own independent country, we said, no, you can't put poor people in jail just because they can't pay their debts. With that said, you know, it's a condition of their sentence. We do our best, but the reality is so many of our criminal defendants themselves are indigent or at least economically disadvantaged, and trying to recover these restitution, you know, costs to the victims, it's almost impossible. With that said, we do have the ability to make claims through the state of California for certain types of losses for serious and violent crimes. And so if you have someone who has been victimized for a serious and violent crime, funeral costs, they need to move, they need to do some of these things, talk to our victim advocates, talk to our attorneys, and we will help fill out that paperwork to try to get some of these funds from the state of California. And then the victim actually can get that money, but it's in a fairly narrow set of circumstances. And we're going to try to speed through our last slide here.
Okay, so a lot of times when we have a criminal case, there is evidence that's taken, and oftentimes for victims of crime, maybe it's cell phones, maybe it's wallets, maybe it's personal possessions that were taken into evidence when we have the case. And so our attorneys and our victim advocates, when that occurs, we'll work together and figure out when during the case those items can be released. And we'll work with whichever police agency has them in property to have those things returned to the victim. And we talked a little bit about what happens with Department of Corrections for notification. The advocates are pretty invested in ensuring that our victims are signed up if they choose to be. There are times when people don't want to know when the person is released. But if they would like to be, that they are informed of how all that parole process works. We can support them through parole hearings, and we have advocates here that do that as well. It's separate from the court system here. Department of Corrections does that. So we work through those hearings as well and help kind of prepare people for when somebody is going to be released back into the community, to make sure that we are acknowledging and assisting with any safety issues that might come up because of that. Okay, next slide.
We were going to add in here because we're basically done with the rights presentation, but Shannon mentioned to me earlier that it might be smart to let you know, or talk about what happens if, you know, our office is not in compliance with Marcy's law. Is there some sort of, you know, requirement of compliance? And there's not, right? We can sort of violate that in one way or another. And it's not like we can be sued for it. So it is in the Constitution, it is the law, but with that said, there's not really a way to enforce it. And so what we do is we do our absolute best. And for the most part, we're fairly used to working with victims. When we make mistakes, and we absolutely do, you know, my personal policy, right, is to own up to it, and find out if there's something we can do to sort of remedy it, you know? If it's the kind of victim that really needs to be heard, and we have sort of denied them that by not giving them some notification about something, there may be another opportunity where we can make sure that they are able to be present and be heard. And we can do our best to try to fix that and be more responsive in each individual case. But in terms of, you know, if we don't do it, what happens? Sort of a whole lot of nothing, but we absolutely do our best, and, you know, our intentions are to always be in compliance.
Thank you, Shannon and Kristen. And as we look at right number 17, to be informed of the rights enumerated in the preceding 16 paragraphs, that's why we're here today and we're doing the training, because it's not just about the DA's office. It's really about what are the victims' rights. And so the more we can educate and inform community members, that's the more victims can be educated on their rights. So we're getting ready to transition into the next part. And so we're going to have a breakout session. So we're going to ask everybody for to answer 3 questions. So you're going to be put into different breakout rooms, and that's where we're transitioning to, right? It's not about the DA's office. It's really about each and every one of you and how you can, in your role, be able to be more supportive. So we have 3 questions that we will ask you to go ahead and work through. And Nick, if you can, or Cassie, I forgot who's putting us into the breakout rooms, but we will also have in the chat those, and we'll also put in a link of the actual 17 rights. So as you're working through this, if you need to reference that, I'll go ahead and put that in the chat. So you'll see a pop-up for your breakout room. Please accept, and we'll take about 15-20 minutes to work on that.
Hey, Nick, I ended up in the same room with Alana. Can you put me in a room where there's not somebody facilitating?
Yep. Hold on. That's DeWanda. Where are you?
Nick, somehow I couldn't choose a room.
Yeah, I don't know what happened there. It
Yeah,
didn't.
can you send me to another room? Because you sent me to the room with the.
So click on breakout if you can. You just click out on the breakout and then
Yeah.
join the room. There should
Okay.
be a room to join.
Yeah, now I see it. Okay, bye. Which one should I go?
It looks like 4 and 3 don't have anybody.
Okay, I'll go to 3.
Okay.
I don't think I have that option to pick a breakout room, Nick.
Shannon, do you see it next to Pulse?
Nope.
Oh, that's weird. Hold on, let me see if I can shove you. Doesn't let me shove you. Oh, you're in. Okay, so you're in room 1. So let me move you to room 4.
Yes, that would be great.
Okay. my God. I think everyone has a. Okay, these are the people that are just not here. Okay. Wait, Cassie, do you want to join a room? I could shove you in one.
I can join random ones, but I was just looking through them.
Yeah, I was just making sure everyone is.
Yeah.
But these people are probably not going to join. Because they're all assigned.
Yeah.
I'm gonna join one for right now. Actually, I don't know if I should. It looks like everyone is. So Lana's room 1, DeWanda's room 2,
I don't.
Susan's room 3, Shannon is room 4. I don't think room 5 has a person.
Yeah, I don't either.
I'll join them. I'll join room 5. Well, actually, I can't. I have to join Alana's. So let me see. I think I'll join room 5 for a little bit, and then I'll just let them know. Let me see here.
We'll just wait for everyone else. Or either they'll just all get kicked back into the room. Okay, and now we're having everyone. All right, welcome back. Welcome back, everyone. Probably have maybe one more group. Yep, I think everyone is coming back in. So at this time, if we can have maybe one person from each group, just share, and everybody can unmute if you want to share. I know from our group, from group 1, breakout room 1, I only saw the initial. It said S. Randon. So I'll open it up for you to share what you all discussed.
All righty. Can you all hear us?
Hi, can you hear me?
Yes.
Okay, so we are client care coordinators and we meet with clients for domestic violence, sexual assault, sex trafficking, and we coordinate with our clients to make an assessment. And then after that, we provide them with referrals to appropriate community partners, for example, with our attorneys, counseling departments, and other resources. And so we talked about how the importance of providing empathy and having listening skills to be able to understand the clients and be non-biased and don't provide any judgment on them. So the importance of just listening to them and then just connect them to the right community partners.
Thank you.
You're welcome.
I see Karina was nominated for breakout room 3. So I don't know when your boss puts you up there.
It's all right. I'm always ready for it. Talk to me. No. So once again, my name is Karina Gomez, and I am the bilingual navigator for the Family Justice Center here in Antioch. And I just touched based on how, to me, these questions actually, they are very close to me in a sense of what my role is. Because the interaction I have with our clients is very, very important because that will determine the rest of our conversation. That will also determine whether they would take the help from us, whether they will want the support, or whether that will push them away, or whether that would make them feel like they're not being helped. Once again, just kind of touching back on what clients do tell us. And so the interaction is everything. So for me, how I interact, and I think someone kind of mentioned it, I'm very big on empathy and also kindness. What does that mean? Having empathy means that they will feel understood, they will feel welcomed, just to even be able to feel free to share what their story is or what their experience has been. The kindness comes in because for me, it's very important that they need to know that I care. I may not know them. I may not know even their full story yet, but they need to know that I care. I care enough because I'm going to try my hardest to be able to provide some type of service or support for them. I think that starting my interaction with empathy and kindness makes a person feel not only welcome, but comfortable enough to be able to speak about things that usually come with a lot of shame and guilt. That in this field is very important to understand that a person, once they feel welcomed enough, they will take the help, or at least it will be a little bit closer to that time that they take the help. So that's more on my interaction with the clients. Number 2, when it says, what information do you generally share with the victim? I say all of it, whatever I have, every little drop. I do say, as much as we may know, we never know enough. And as information as it comes, we can always constantly be learning. And I shared with our group that for me, information is a gift, and I love to gift that gift because a lot of things that we know and we think that everybody knows, it's not always the case. And that information can ultimately be what changes somebody's outcome because of something that they did not know. So I definitely think that whatever information I got, like I said, I will, every little drop, I'm more than willing to share it. And I'm constantly doing my homework to know as much as I can. So I definitely love to still attend, like when it says, what information have I learned today, and utilize. Honestly, as a family justice, we have such a close partnership with CalVCB that we constantly have to know kind of the way that is processed, but it is a great refresher, and it's great to be still in tune with how things are, so we could constantly be giving the right and accurate information. So me, as in speaking for my group, and they say they agree with me. So I hope I'm not stepping out of turn in them saying is that we definitely with our clients, we may not be able to give them what they need in that moment or right away, but we do try, and we try to show them that we care and that we are trying to provide some type of support for them as much as we can and as much as it's possible.
Thank you, Karina. That was great. B. Zamora, you asked to be taken off of mute, so I am guessing you want to share. So go for it.
She was in my group, but we couldn't unmute her.
Oh,
I don't know, Nick, he's our tech guy. Can you try to unmute her?
They're unmuted.
Yeah, they're unmuted.
Yeah, but yeah, we couldn't hear her. So maybe it's your audio.
well, does anybody else want to share? I think we have time for one more from any group.
Group 5 didn't have but a few minutes in group because 2 facilitators were put into a different group. So when I did get into the group, it was cut off. So, but I heard from Alana, Adeline, and Miss Michelle Simpson.
And by the way, when she says Alana, she doesn't mean me.
So if Miss Adeline, you were talking when I came into group, do you have anything you want to share out with the group?
No, I think I'm the outlier. I think I'm here more as the student than as the contributor, because in my role, as I said, at Children's Hospital before I retired, I was a referee into the system. And now I'm looking at how that system works for those people I referred. So I'm learning as I go here and listen to all of you professionals. But thank you.
Thank you so much. Ms. Simpson, Mitchell Simpson, would you like to add anything?
I think primarily we talked about kind of our roles. For me, it's family violence prevention, both at the Solano Family Justice Center and Fighting Back Partnership, working with survivors with legal issues, victims of crime, getting basic needs, being able to have the ability to work with community agencies so that we could collaborate and share information so we can learn what's available to different folks who need our services.
Thank you. And for the rest of the Group 5 members, I sincerely apologize for the mix-up that you did not have a facilitator at the onset of the breakout rooms. You guys have a great Thursday.
Well, thank you, everyone. That brings us to the close of the presentation. I don't know if there's any questions. We have been using the chat. I didn't see anything in the chat, but if I overlooked it, feel free to jump in. If not, I just want to remind you, in addition to your role in your profession, your job, maybe you volunteer, or maybe just as a community member, you know, a family member or a friend who we hope, but if they are unfortunately the victim of a crime, this is also information that you can share to help them, support them towards healing and recovery. So thank you to Susan and all of Nick. Everybody give a round of applause to Nick and Cassie who did our tech. And Nick also was our DJ earlier when we came on. So we want to wish everyone a happy holidays. And Susan, if you have any closing words, I will turn it back over to you.
Yeah, what I want to say is that thank you to our partners in the DA's office who have really done a great presentation, as well as your day-to-day work with us. And thank you to all of you who came today to learn together. I think this learning community really means a lot to us. I really appreciate it, and I definitely want to stay in touch with you. Also, I want to acknowledge that, you know, there are a lot of tough things happening out in the world, right? And there are some of us who are suffering because we have families either, you know, in Gaza or in Israel. You know, I hear a lot of polarizing news out there, but I still want to find joy in our work every day. And I would like to wish that joy to all of you, and enjoy your holidays and find joy and peace. Thank you.
Thank you all.
And we'll have a great year next year.
Yes.
So please fill out your evaluation and send us your comments. We would love to create this learning community together. So Nick, where's your music?